or is perhaps now obsolete. Some thoughts from our panel of experts. Joining us, Ben White, Wall Street correspondent with the Financial Times, and M&A attorney Fred Lipman with the law firm Blank Rome. Nice to have you here.
Thanks for having us.
Ben,
nice to be here.
Let me start with you, if I could. I think one of the questions that's being posed at this big symposium by the Wall Street Journal is whether or not the public company model is becoming obsolete because of some of the things that we've mentioned. What are you hearing, and what do you find when you do that kind of research?
Yeah, well, I think things might be changing a little bit. That's certainly been the argument for the last, year, 2 years. But we've had the U.S. Supreme Court come out with an important decision, making it harder for shareholders to file lawsuits. Chris Cox at the SEC looking to ease up Sarbanes-Oxley restrictions, particularly on small companies. And as you mentioned before, maybe the buyout boom finally sort of hitting a peak. So I think, it's still tough for public companies, but it may be getting a little easier.
A little easier. Do you agree, Fred, or not?
I think it's getting a little easier, and I think the public companies have a great future. I think all these private equity deals that are now, as you've seen in the past and will continue in the future, are going to ultimately have to go public again to maximize their valuation. So it is just a temporary phenomenon as the private equity firms basically pay management in many cases more than they can earn as a public company. And that, in fact, induces a lot of these private equity deals.
Which is a very good point, Ben. The other issue has been the Sarbox regulations here in the United States, which many people feel has favored the London market. So perhaps the part of the equation should also be, should the public model here in the United States be reformed versus that's going on in London?
Right. Certainly there's a lot of talk about the SEC sort of adopting a more flexible approach similar to the FSA in London, more of a sort of principles-based approach rather than a rules-based approach. And in terms of where companies want to list, one of the big problems for small companies is the costs of complying with Section 404 of Sarbox, which talks about verifying your internal controls, which costs a lot of money to do that, particularly for a small company who might look to London to list rather than the U.S. So that's one area they're really focusing on.
Fred, you deal with a lot of these companies, and we're touching a lot on private equity these days, but with the subprime mess, some people feel as though that's the beginning of the tipping point, that we're nearer the end of the PE and M&A cycle. Do you agree with that or not?
Not necessarily. I think this may be a temporary phenomenon, and the market will recover from that. On the other issue, I want to say the SEC is making great strides to try to lower the cost of complying with Section 404 Sarbanes-Oxley. And the only thing I think is the major problem in the last 10 years, you have to be bigger and bigger in terms of valuation in order to go public. And many companies are choosing the London Stock Exchange for that purpose. I think ultimately the U.S. exchanges will catch up and provide more access for these smaller public companies that can't qualify for bulge bracket underwriters.
Mm-hmm. Very interesting. Gentlemen, thank you. Ben, Fred, pleasure to have you with us.
Thanks so much.
Thank you.
Straight ahead, we'll be coming up on the half hour again, so we'll update the markets once again for you.
Time for the smart money right out.